Hi, my name is Laura Solomon, and in today's session, I'm going to be talking with you about copyright basics for all library staff. I'll be breaking the content down into three areas: misconceptions that many people have about copyright law, the basics and foundational information you need to know about copyright law, and lastly, we'll take a quick look at some issues about copyright that involve social media, using images, and some other associated topics. The first thing I want to say, though, is actually a disclaimer. I am not a lawyer. That is that acronym IANAL. Always go with your library's legal counsel, especially because that's the person or organization that will be possibly defending your library in the case of any legal issues surrounding copyright. But not only am I not a lawyer, you're going to see, especially when we get to fair use, that everything has to be evaluated on a case-by-case basis. I'm going to disappoint you early on. When it comes to copyright law and to fair use, there are very few hard, heavy rules. What I'm focusing on today is giving you the tools and information you need to evaluate your own uses and cases as best and as clearly as possible in light of what the current law is. So let's start with those misconceptions that many people have about copyright and getting those cleared up for you. Let's start here. Copyright law is about money. This is probably the most common misconception surrounding copyright. The U.S. Constitution actually says that copyright law is created, quote unquote, to promote the progress of science and the useful arts. So the actual intent of copyright law is actually first and foremost to encourage the distribution and spreading of original and creative works that can possibly benefit the public. The founders of the U.S. valued a well-informed public, and so copyright actually fits right in and is intended to fit right in with that goal. And also the values that underlie copyright law fit very nicely with the values that libraries have about making sure that people have access to information. The second most common misconception is probably that libraries are constantly involved in litigation surrounding copyright. It seems like we hear about this threat all of the time, but as it turns out, actual lawsuits are very rare. Receiving cease and desist letters, sometimes referred to as C&Ds, or paying fines, are more common endpoints for possible litigation. But actual lawsuits are really not very common at all. Also, unless a trial says so and the end settlement says so, it's not actually copyright infringement. Getting a copyright cease and desist letter or paying a fine doesn't count. But you're probably worried about breaking the law because it does happen, and it's possible. You'll learn more today about that, of course. But because of the original intent of copyright, which is to benefit the public, museums and libraries and schools and similar kinds of entities have a special status and are able to do more than, say, a business. Libraries need to provide equitable access to information. So even if your library was to be taken to court, and let's say that the plaintiff won, they're actually not going to get much in the way of money out of it. There are special limits on how much penalties a library or any other kind of similar organization can be fined. So lastly, the 11th Amendment says that state entities can't be sued in a federal court without actually permitting it. They have to have their consent. And so this is probably one of the major reasons those kinds of court cases don't actually happen very often, because they have to actually have the permission of, say in this case, the library to go to court at all. So number 3, are the ways in which sometimes copyright law gets misused in language. So things that are protected by copyright law are not property. And the way that we see this play out is that people will refer to copyright infringement as something like stealing or piracy. Those are actually not the same, simply because the things that are covered by copyright law are not considered under the law to be property. So the things that, for example, are owned, quote unquote, by someone who holds the copyright is not quite the same thing. So when someone uses something without permission, that's infringing on a copyright. It's not stealing property. It's not stealing that thing. And there's an importance that's part of that distinction, because when we do understand, I think, inherently that stealing something is morally wrong. But some kinds of uses of works, of things that someone created that are not tangible, and we'll talk more about that in a minute, are not the same thing. So we need to be able to disseminate information. So every time that information is used, even without permission, that is not theft. The fourth common misconception is that there are really solid rules that give definitive answers about whether or not something is copyright infringement or not. Often the answer to a specific copyright question or figuring out something in a particular scenario is the actual scenario at hand has to be analyzed to decide whether or not the use is fair. We're going to be talking about copyright law and fair use in just a little bit. So there are no, at least very few, rules that are would be set in stone. And this is a great book, by the way, by Carrie Russell, called Complete Copyright for K-12 Librarians and Educators. And she points out that this quote here, to set copyright rules in stone, would be to freeze the law. And that's not possible, particularly because things that we create as human beings are evolving all the time. So one of the things that we're going to be looking at in a little more depth is going to be fair use. And that's a really important part of what we as librarians do and how we make decisions about what's okay to use and what might not be okay to use. And that brings us to another common misconception, which is that fair use is too hard. It's really not as hard as you might think. It does require a little thought, but it's not that complicated. There are 4 factors that determine whether or not something being used is fair use or not. We'll cover those. And you don't need a law degree to figure it out. And you don't need a lawyer every time either. It's part of our responsibility as library professionals to understand fair use, and because we facilitate access to information for people, this is something that we really need to be aware of and understand. So why are there so many misconceptions, and why are they so solidly ingrained, it seems like, into our consciousness? So most copyright law as it stands now, a lot of it came into being through a law in 1976. And at that point, librarians wanted some clarity on what could be reproduced. And the thing that was really the elephant in the room at the time was the advent of the photocopier. And so librarians and library staff wanted to have some really clear guidelines to solve that immediate problem of what do we let people copy on these machines, rather than fully understanding what the foundations of copyright law were or how they played into the use of these machines. And so librarians basically just wanted to figure out how to comply with the law. And so what that meant is they ended up giving some power to publishers, because publishers were concerned that everybody would just start copying everything. And so they happily started putting out these models and guidelines for fair use. But those were never actually what Congress or the law intended. The widespread use of fair use guidelines led to a lot of these misconceptions. They were created oftentimes by publishers and not really having copyright law or the intent of the Constitution behind them. So very few librarians knew, or even today know, the 4 factors that are involved in determining whether or not something is fair use. So let's take a look at the basics of copyright and understanding what it is, what it does, and then we'll, of course, get to fair use as well. So the first thing we should talk about is what is actually protected. The kinds of works that are protected are, they spread, they really run the gamut. But 2 things have to hold true no matter what kind of thing it is, what kind of work it is. First, it has to be an original work of creativity. So that means that it can't be something, of course, that someone else has already created. I think that's probably pretty well known. The next part of this, though, is it has to be able to be created into or put into a tangible medium, which means it has to be perceptible to people somehow. And this is important because it means that whatever has been created has to be somehow perceived by others or reproduced in tangible copies that can somehow be distributed to the public. And if something meets both of these criteria, then it's immediately protected by copyright. It doesn't have to be a registered copyright. As soon as it's created, then it is protected by copyright law. And being tangible is very important because simply thinking something in your head, even if it's original and creative, doesn't mean it can be copyrighted. It has to be somehow made tangible in a way that other people understand that it does exist and that you were the one who created it. But not everything is protected. So a collection of facts, for example, like a bibliography, are not protected. Now, you can have a collection of facts, like a textbook, for example, and the textbook is protected. But the facts inside are facts. They're things that are true, regardless of whether or not they're fixed in a tangible medium. So those are not protected. Federal government documents are not protected, and anyone who works in a library that might act as a federal repository, this is probably old news for you. But again, this is part of that distribution of information idea, so federal government documents are not protected. Procedures and processes, because those are part of how information gets disseminated. So, for example, a procedure might be how you track your time at work. You can't copyright that procedure. No, you can't say, well, we decided to use our calendar and our work schedule this way, so nobody else can do it that way. It doesn't work like that. Book titles, you probably would have already guessed this one just thinking about it, because how many times have you run into a book title that was the same as maybe another book title? It happens all the time. First form, so for example, haiku, iambic pentameter, those cannot be copyrighted because they are used by many different things. Standard arrangements like a calendar, you can't copyright a 12-month calendar. That's a thing that just is, and everybody uses it, and it's in some ways related, I think, to procedures and processes. You can't copyright. So those things are not subject to copyright. Your ideas aren't protected either, and I just mentioned this a couple slides ago when we looked at whether or not something could be protected, because it had to be in a tangible medium. Remember, if it's in your head, if you have an idea, copyright does not protect that. The free flow of ideas is important, of course, for disseminating information and creating new things, but and without that, we would have virtually nothing new as human beings. But copyright covers the expression of ideas, not the ideas themselves. It copyrights how an idea is expressed. Another thing that we need to know about copyright is how long does it last? Now, this sometimes can be a little different depending on what country you're in, but typically here in the U.S., it's considered to be the author or the creator's death, so at the point at which they passed away, plus 70 years. And also the year of death is rounded to the end of the calendar year. So I think, for example, Marvel comic creator Stan Lee died, I think, in 2018. So his copyrighted works are protected through the end of 2018, the year that he died, plus 70 more years. So the comics that he wrote, for example, will enter the public domain, which we'll talk about also in just a minute, in 2088. Another common mix-up that I've seen is the idea of plagiarism versus copyright infringement. People, I think, often confuse these two ideas. You can do both at the same time or separately. Copyright is federal law, but plagiarism is not a law at all. Plagiarism is saying that you're the creator of a work, not just using the work. So, for example, I know for a fact that there are bootleg digital copies of all of my books out on the web. I've written several books. They're all out there as bootleg copies in one way or another. That is copyright infringement. It's not plagiarism, because whoever has been spreading those digital copies is not saying that they wrote those books. They're simply making copies of them. I'm still the creator of them, but that's just the way it is these days. Things are out online. So it's copyright infringement because the bootleggers are distributing it. They're not claiming that they wrote those books. So I mentioned that there are 4 factors that go into determining whether or not something is fair use. But fair use itself is actually one of 4 scenarios that you have to look at when you are trying to figure out whether or not you can use something for another purpose. So copyright, we've just been talking about. So that's the idea. It's the copyright is the creation of an expression of ideas. We talked about what could and could not be copyrighted. That's all up until this point. We have been talking specifically about copyright. But there are 3 other scenarios that we need to look at. And of course, I've been mentioning all along fair use, and we will get to that, I promise. There are 2 others, though, and you may be familiar with these, at least to some extent. The next one is Creative Commons. I'll talk about that in just a moment. And also public domain. And I mentioned that also when I mentioned that comic writer Stan Lee, his works will enter into the public domain 70 years after he passed away. So copyright is whether or not you created the thing, or if we're talking about the use of something, did you get permission to use the thing from the person who created whatever it is, or did you purchase the rights to use whatever the thing is? If you couldn't, or at least say yes to any of those, that doesn't mean still, though, that you couldn't use the thing, because it could fall under one of the other 3 conditions. And that's what I want to talk about. But before we do that, we should probably take a quick look at what do copyright holders actually have the rights to. All of these things. And first, of course, the right to reproduce. Copyright holders do have 5 exclusive rights, and the 6th one here only applies to specifically mostly audio and video kinds of things. But if I create something, I have the right to reproduce it. I also can create what are referred to as derivative works. So if I create, for example, I wrote a book, if I decide that I want to write something that is based on that book. So let's say I write a story, that story is published, and I decide to write a book or a story written in that same venue that book was. I can do that. I can distribute copies of it because it's mine. If it's something that can be performed, I of course can perform that publicly. You can display the work publicly. So you have all of these rights as the copyright holder. And as you can see there, if you created something like a sound recording, you can also use audio transmission, like for example, playing it online or on the radio or something. So that applies. That's a little more specific. So let's get to fair use, though, because just because you're not the copyright holder or don't have permission from the copyright holder to use whatever it is, doesn't necessarily mean you can't use it. So let's look at these 4 factors that I have been referring to for some time. The first one is we need to look at the purpose of what it is that you're going to be doing. Why do you want to use a copyrighted work? Because remember, back to the original purpose of copyright, which is to spread information and to have an educated citizenry, right? So fair use actually favors nonprofit and educational uses. So if you have a talent show, let's say at your library, and one of the participants uses pop music, that's not educational, but it is a nonprofit. Some uses can fall between 2 extremes. It's more of a spectrum. And that doesn't mean that everything that libraries do, by the way, is automatically fair use, though. Just like not all commercial uses are necessarily not fair use. All 4 factors have to be taken into consideration for all cases that you're looking at. You can't look at just one and say that we're a nonprofit, we're a library, we can use it. That's not how that works. It also has to include a consideration of the nature of the publication or the material that you're using. Is it published or unpublished? Unpublished materials are less likely to be fair use, according to the courts, which makes sense because they weren't out there for the public really to begin with, so they're less likely to be available as freely. You also have to consider if the work is fictional or if it's factual, because items that are more fictional or more creative are generally more protected than those that are factual. We covered a little bit ago how facts are not covered by copyright. So the more creative or less factual something is, the more likely it is to be covered by copyright. Another important piece that has to be looked at as part of your consideration of fair use is how much of the material are you planning to use. Little parts of the material, small portions, are generally considered to be a better bet, I think, than bigger chunks of material. Because the amount of the copyrighted work, as it increases, the likelihood that it's going to be fair use decreases. So for example, you could say, I'm going to copy every part of this book except for the last 3 pages. At that point, it's not really fair use. I don't think any court would decide that that was fair use. It's far too much. Also, courts will look at the nature of the copying, whether the essence of the work was copied, and there's no magic number. So, again, in the example of you decide to copy an entire book except maybe the last 3 pages, that really is the essence of the book. That's part of what plays into that. If you copy 5 pages out of a 200-page book, again, remembering there are no magic numbers here, it's far less likely to be the essence of the work. So you're more likely to be able to argue that that is, in fact, fair use. The context of what's being used also matters. There was a case where a woman wrote a coffee table book about the band The Grateful Dead, and she used 7 reproductions of that were of some of the tour posters that were used by the band, and some of the tickets. She reproduced those in the book, and she didn't get authorization for that. And it ended up going to court, and the court ruled that it was fair use because the context was different. In this case, they used the word transformative. The original purpose of the posters and the tickets, of course, was to promote a live band concert. The tickets was so you could actually get in to see the band concert. Using them in the book is not the same context. It isn't the same use. So it's fair use because it was, as the word was used, transformative. It was being used to tell the history of the Grateful Dead, not to advertise a live show or to gain access to a live show. So context of what's being used also matters. So what is transformative use. Basically, this is any kind of secondary use that isn't the same as the original use. In the case of the woman who used posters and tickets, that was a secondary use. So that's not what those items were originally created for. They were not created for the book, and it was not for the same purpose. It repurposed the original works, the posters, the tickets, and this actually will continue to advance the law of surrounding copyright. Because remember, the original idea of copyright law is not first and foremost to protect the rights holder. It's actually to enable the dissemination of information. And new expressions of works and new expressions of ideas, those are transformative. Another thing that comes under this idea, parodies, satires, those are also protected under fair use. That's why we can have things like, for example, Saturday Night Live, which is making fun of things all the time. They're not having to worry about copyright with satire and parody because that's all covered under fair use. The last factor that has to be considered when you're looking at whether or not something is fair use is its economic impact. Could some kind of economic harm of the use of this material, could it potentially cause some kind of economic harm to the rights holder? And this can go right in hand with number 3, how much you're copying. So going back to the fact that there are bootlegged copies of my books out there freely available on the line, that does have economic impact on me. So that clearly not going to be an instance of fair use. Aside from the fact it's the entire book, it does have an economic impact on me. So if you have a workbook, let's say for students, and you copy the entirety of that workbook and give it out to your students, that's economic harm because not by not purchasing those workbooks for students, that's harm to the original publisher or rights holder, even though it's for educational use. Copying a page or two is probably going to be fair use, because you're not really causing much in the way of economic impact. Also, if the work is really obscure, if it's out of print, for example, it's not commercially available if you can't go buy it anymore, that's also more likely to be considered fair use. Keep in mind, though, that even if there are, say, fees involved with using something, that doesn't automatically make use of it unfair, because, for example, their radio stations pay royalties for the music that they play. And if your library does this, for example, in the talent show example I mentioned a few minutes ago, one way that some organizations have gotten around this is not to use all of the piece of music. Also, as I found out from Carrie Russell, the author of the book that I mentioned earlier, sometimes there are not even mechanisms for institutions to get permissions or licenses. So, for example, some schools, there's no licensing for some kinds of music, even though there might be for higher education. So in that case, something is probably more likely to be fair use if there's not actually a way to license it. When it comes to fair use, there sometimes, of course, can be some things you have to consider. There's those 4 factors. There's a neat tool that I wanted to share with you. It's called the Fair Use Evaluator, and it comes from a website called librarycopyright.net, and it helps you evaluate your individual scenario to decide whether or not it's going to be fair use. Now, again, this is not going to be the end-all, be-all. Certainly, if you're really, really having a hard time deciding, this is where you're going to involve your library's legal counsel. But this is a really nice tool that will help walk you through some of these considerations that you can use when you're trying to decide whether or not something is or is not fair use. Some other things that you should know about fair use. There are no specific, I mentioned this before, I think, no magic numbers when it comes to the amount of a work that you can use for it to be considered fair use or not fair use. Your institution may have a policy, but that's not the same thing as the law. The law does not have any kind of specific requirement saying you can only, say, use 10% of a work and then it's fair use. Also, an individual websites or entities and license agreement can override fair use. So, and lastly, the Supreme Court is actually the final decision maker when it comes to fair use. But how many copyright infringement cases actually make it to the Supreme Court? Very, very few. But that they are the final arbiter if it were to come to that. As a nonprofit employee, if you're trying to understand fair use and you're using these criteria to determine whether or not your use is going to be under that umbrella of fair use, there aren't a lot of things for a rights holder to come back with if they try to say it's not fair use. But also, lastly, and this is perhaps the most practical immediate use or consideration for many of us, is that you can't claim fair use simply by giving attribution to the author. So if someone makes a copy of my book and says, hey, here's Laura's book, Laura wrote it, that is not fair use. Fair use and attribution are not related at all. Even if let's say you took a blog post and said, or an image that I created and said, hey, this was created by Laura Solomon, and in fact, here's a link back to her website. That is not the same, and that will not clear you of having to consider whether or not something is fair use. Fair use is about how someone is using content, and it's kind of one of those wishy-washy gray areas where lawyers often say it depends, and hopefully you're starting to see that from the considerations that we've had. A couple other things I mentioned earlier on, right, that there were 4 scenarios that have to be looked at when we're deciding whether or not we can use something, and fair use was only one of those. Copyright obviously was the first. We had fair use, and there were 2 others. The third one is Creative Commons. When you create something, it's automatically copyrighted. Remember, you don't have to go register the copyright. As soon as you create that thing, as soon as you express that idea, it is copyrighted. And all exclusive rights of being the copyright holder go to you as the rights holder. However, what if you don't want that? What if you want to be able to share your work or share it in specific ways? That's where Creative Commons comes in. You don't give up your copyright, you just refine it so that it does what you want it to. You go to basically creativecommons.org and you answer some questions and you get a license to fit your needs. And that is recognized as a legitimate license. If you're wanting to use something with a CC or Creative Commons license, you do have to check the attributes, because with Creative Commons licensing, you can give away or keep specific rights. It's not an all or nothing proposition like regular copyright. So the attributes will tell you specifically what you're allowed and not allowed to do with that work. And this video here, which I encourage you to go watch, is something that explains this very nicely if you're interested in learning more about how Creative Commons works and some of the attributes that can be applied when you have a Creative Commons copyright. And in a way, Creative Commons is one of the easiest situations to have if you're wanting to use something that does have a Creative Commons license, because the CC license will always pretty much tell you exactly how something can or can't be used. The last scenario, and probably the easiest for many of us, is that of public domain. Interestingly enough, the phrase public domain actually is not in the U.S. Copyright Act, but it is commonly referred to or used to refer to content that's not protected by copyright law. So anything that is in the public domain can be used freely. There's no permission that has to be gotten from anywhere. You don't have to pay any kind of fees or compensation. So things that are in the public domain are desirable, of course, because you don't have to do pretty much anything in order to use them. And they can be modified, they can be reproduced, they can be spread wherever. There's basically no limits on something that's in the public domain. Federal documents, remember we talked about those earlier, are in the public domain. Usually things end up in the public domain in one of these ways. First, of course, the copyright expired. Remember, Stan Lee's things are copyright protected until 2088. So at that point, the copyright expires, and then things are freely available to use however anyone would like. Federal government things, we mentioned that. Those of you who work in libraries that are federal repositories, you're well aware of this. You can't, remember, copyright protect things that cannot be expressed in a tangible or perceivable way. So an idea in your head can be in the public domain because it hasn't been affixed in any way that other people can perceive. Also, things that were created prior to March 1st, 1989. And this is a U.S. thing, by the way. Prior to that date, notice of a copyright was necessary on published works. So, for example, if you have a book and there was no copyright in it, then and it was published prior to that date, then it's in the public domain, because prior to that it had to have an express declaration saying this thing is copyrighted. Without that, that item will be in the public domain. And lastly, it's not original enough. Like let's say a timetable of a train schedule timetable, literally, it is not going to be sufficiently original under the idea of copyrights to be copyrighted. So it's going to be in the public domain. So these are all examples of things that could be or are in the public domain. Now, this is where there's sometimes, I think, a little bit of confusion because sometimes people will look at these factors and think, well, what about Shakespeare? Is Shakespeare in the public domain? Well, yes and no. So the original Shakespeare is in the public domain, but new versions that have, for example, annotations or explanations or illustrations or any other thing where someone has expressed additional ideas and then made that into some kind of tangible or perceivable medium, that can be copyrighted. So an adaptation of a work in the public domain almost certainly has copyright protections. This can include translations, annotated versions. So Romeo and Juliet might be in the public domain, but a new version with pictures is going to be copyrighted. It does differ from country to country. You've probably noticed that at least a couple times so far in the session, I have noted that this really is specific to the U.S. Things that are created, for example, here in the U.S. do not necessarily have the same protections overseas. So a U.S. government work might be in the public domain, but could be protected by copyright in Canada. Also, not every country has the same duration in terms of copyright. So in the U.S. we have the death plus 70 years parameter, I guess. Copyright duration in another country might be only 50 years. So that can get things a little confusing for sure, but be aware that especially here in this session today, all of the things that I'm talking about are in many ways specific to the U.S. Okay, so we've taken a look at misconceptions. We've looked at the foundational things that everyone should know about copyright. We've looked at the 4 factors surrounding fair use, which hopefully you'll be able to apply going forward. So let's take a look at some of the things where maybe copyright comes into our work and in a more practical way that we might have to contend with, and things we should be aware of. The first thing I want to talk just a little bit about is copyright in terms of social media, which can get kind of messy. And you have to be really careful when you're using things in copyright that are potentially copyrighted in social media. And sometimes it doesn't seem like that should be an issue because in social media, we're sharing things all the time, willy-nilly. A lot of the time we're not even attributing those things. And so really in many ways, I think social media constitutes a kind of a wild west of copyright. So some things to know that just to be on the lookout for, I think. Now I'm showing Pinterest here specifically because at least at the time that I put the session together, this was the case, and it could apply to other social media platforms, new or old, at any time. So you need to be aware of it. You might think that just by spreading something on social media, just by the fact that somebody else already posted it, that it's fair use. But keep in mind that agreements with each social media platform override fair use guidelines. Remember, I mentioned when we were talking about fair use that individual and licensed, I can't say that, and license agreements with certain platforms or web services can override fair use. So they can specifically say, no, fair use does not apply. And in fact, Pinterest is one of those places online that does that. Don't assume that providing credit for a work or even a link back to something clears you and makes it fair use. Unfortunately, this is not true because remember, the holder of a copyright has the exclusive rights to publish that work, and giving credit is not going to make you immune from some kind of legal problem later on. So Pinterest actually says, hey, this doesn't apply. And if you look at their terms of use, you can actually see the full thing here. I'll give you the link. They mention in their content, it means that you can post anything that you want. That's fine. You can do that, but you are responsible for it. What that means is they have basically taken themselves out of the equation, and if somebody complains about it, it's your problem, not theirs. Now, if you've been on Pinterest for a while, you're probably aware that sometimes things do get taken down because of a copyright infringement claim. And sometimes you'll have a pin and it will be gone, or you'll get a notification that a pin was removed. Maybe you pinned it, you didn't know it was infringing on anyone's copyright because, again, you don't know where anything came from, especially on these kinds of platforms. So this is typically not the type of thing that ends up in court, but you will often see things like more of a cease and desist approach, where like, that's not yours, take it down, or the platform gets the complaint in this case and takes it down, and you're responsible for that. Now, if the rights holder decided to pursue other action past this point, then what Pinterest is saying is that's on you. You're going to have to contend with that. So most of the time, you're not going to have major legal issues simply because you posted another picture of that cute little house you saw. But if somebody says that, hey, that was my photo, it gets taken down. Usually it doesn't go beyond that. But Pinterest has come out pretty clearly, and I don't think they're the only platform that have done this, and said, when you agree to use our service, you understand that if there is a problem, we're not getting involved with it other than to remove it. Then there are services like Instagram, which doesn't even allow reposting. And I know for myself, I have found that to be quite irritating, since sharing is such an, I think, integral part of a lot of social media use. But it's actually in violation of Instagram's terms of service to repost things. And you'll notice there is not an immediate mechanism for doing that built into Instagram. This is one of the ways they probably use to avoid copyright infringement, is that you can't share it, which means, of course, you are immediately responsible for it because you didn't get it from somewhere else on Instagram. But the thing is that given the platform that Instagram is and how it works, most users are okay with sharing. So even though there's not a mechanism built into it, that doesn't mean that people don't do it, because of course people find other ways to do it. And often people want their stuff shared. But again, this is another way where Instagram is kind of removing itself from the equation and saying, hey, you know, the responsibility of not violating copyright is on you. But just a word of warning here. There is ignorance of the law, or the fact that something was protected by copyright, is not a defense. You've probably heard the expression ignorance of the law. Doesn't count as a defense. That applies absolutely here. And unfortunately, and this is not meant to scare anyone, but it's something that you should be aware of, is that some photographers and attorneys are in some ways acting almost like ambulance chasers, and that they are looking for copyright infringement of their materials because it's a way that they can get money. Unfortunately, with copyright infringement, you can't claim that you didn't know what you were doing, and you're probably going to be on the hook for damages under the statute. And sometimes it's not even that the photographers or the lawyers are, you know, out hunting for this kind of thing in a sense. They want money, but it does happen. And I can tell you that from my own experience, it has happened in a library. I work for a state agency. We deal where we are providing broadband internet for public libraries here in Ohio. And when there are things like FBI claims, because we handle all of the IP addresses for public libraries. So if someone is, say, BitTorrenting off of a library IP, that information or those inquiries all come through our office. And that can include copyright claims. And we had an instance where a library had not gotten permission to use a stock photo from one of Gannett News's stock photo sites. And if you're not familiar with Gannett News, they're one of the largest providers of stock photos in the world. And this library took the image without buying the license, and as a result, they had to pay a bunch of money. Fortunately, it could have been way worse than it was, but I don't know whether they understood at the time that that was not okay to do, but it did result in a fine for that library. So ignorance doesn't protect you from anything. But while distribution rules are still fuzzy in social media, it's generally acceptable to redistribute images that were originally intended for public viewing. And so if you were thinking, well, how does anything get shared out on any social media platform? Of course it does. Am I telling you you can take whatever you'd like and share it out? Of course not. And also remember that attributing that image will not necessarily make you immune to any problems. It helps for sure, because you're at least giving credit where credit is due. But a lot depends on how you intend to use the image. When you can, cite the original source and link back whenever you can. Don't assume that this means that you can't ever post anything or share anything to social media. Again, remember fair use. That is always going to be your first resort for any of this. Now, something that's kind of adjacent to this idea is the whole idea of using images online. And I mentioned the problem where we were notified that a library had essentially used a stock image without permission and ended up in some big hot water. When my son, he's now in college, by the way, was in grade school, he was literally told, almost verbatim, go anywhere you want on the internet and using Google Images and find images to use in your projects. This, of course, drove me absolutely bonkers because that is completely not okay. Just going to Google Images and looking for an image and then saying, oh, isn't that a cute picture? I'm going to use that one on social media or on our website or in print, wherever. That does not work. Google does not screen images to see if they are, for example, in the public domain or can be used under variations of Creative Commons. They do have a search feature where you can filter by that, but by default, it does not do that. And even the filter is not a guarantee. So be very careful using that. Make sure you look at things specifically before you start using them. Images, remember, as soon as something is created, it is covered under copyright. You don't have to register it. You don't have to go say, hey, I created this thing and I would like the official registration for it, please. As soon as you created it, it is protected. So that what that means is that even if someone hasn't specifically said this thing is protected, it is, unless they have said otherwise. That's the thing here. And that's one of the reasons that people use Creative Commons, is because, remember, it's created by default, it is protected. And what that means when you are looking at Google and Google Images and anything like this where images come up online, it doesn't mean it's freely available, even though apparently some school kids are being told that is the case. It is not true. Keep your library out of hot water. Also, when you are buying stock images of any kind, you have to remember that, yes, hey, that's good. We want you to do that. That's, and often it's not that expensive to do, by the way. But when you buy that license, it is not a license for everything. You need to make sure, and this is different depending on the service that you buy from. You may not be able to do everything you want with a specific license. So some will differentiate between different kinds of licenses when you buy a license from them. And so that's really important to know. This is a slightly dated graphic, but it still stands up in terms of nowadays, in terms of the test of time. It's a great little flow chart. Can I use that picture? And it gives you a really nice visual way to figure out whether or not that thing you found that was so absolutely perfect, say on Google Images, is going to meet your needs, and whether or not you can use it without an issue or under certain specific circumstances. So I encourage you to use this. It's really handy. So to sum up, whenever you would like to use something that you did not create, you need to go through these steps. First, is it infringing? In other words, if you use it, will you be using someone else's stuff that could potentially be protected? So to go back to one of our earlier examples, that, say, schedule from the local bus transit authority, that is not going to be copyright infringement. Almost certainly not. So you're not going to have to worry about that. Is there a specific exception that allows your use? And this is where maybe there's a Creative Commons license that says, you know what, you can use it to do this specific thing, but not this other specific thing. Is it, if there isn't, let's say it's not covered under Creative Commons, could it still be fair use? In many cases it could be. Is there an alternative? If you can't figure out how to use it under any of those other prior conditions, is there something else you could use? And if you really, really need it, or this is the absolutely perfect thing and it doesn't meet any of those other criteria, or there isn't an alternative, could you get permission to use it? That's always an option. And particularly because we work in libraries, that's perhaps even more of an option than for the average person. So these are all ways that you could potentially get something to be usable for your particular situation. This is probably one of the best things that I can recommend for you. First, copyright.com has the Copyright Clearance Center, I should say, has a great video that goes through some of these basics for you in a very succinct way, so I recommend that. Also, and I've quoted Carrie Russell probably several times here, she has a great book called The Complete Copyright for K-12 librarians and educators, and this is all geared specifically to what we do, and I think is a great very in-depth look at some things and maybe things that we didn't get to today. So that is the end of our session today. I hope that you found this useful and that you will be able to use some of these criteria when you're evaluating use cases in your own library. Thank you so much, and good luck in your future copyright-related endeavors.